Imagine India suddenly entering a national emergency, armed forces requiring immediate support, national defense systems demanding urgent funding, and corporate India being called upon to contribute towards national security and defense preparedness. Now imagine directors refusing support due to procedural confusion, shareholders questioning whether corporate money can legally fund national defense initiatives, auditors raising concerns regarding governance approvals, and compliance professionals struggling to determine whether such contributions require shareholder authorization. Can companies contribute directly to national defense funds? Can directors independently approve such contributions? Can shareholders object to national defense related spending? Does corporate law treat national defense contributions differently from political donations and charitable funding? Today, we uncover one of the most patriotic yet legally significant governance provisions under the Companies Act 2013, Section 183, relating to contributions to National Defense Fund and other funds approved by the central government. Welcome to Corporate and Securities Law Compass, navigating law with clarity. Section 183 of the Companies Act 2013 represents a unique intersection between corporate governance, national responsibility, and statutory compliance. Unlike ordinary charitable contributions under Section 181 or politically sensitive funding under Section 182, Section 183 deals with contributions made by companies towards national defense and nationally important government-approved funds. This provision reflects an important legislative philosophy. Corporate entities are not merely profit-generating structures existing in isolation from society and the nation. Companies operate within the protection of national infrastructure, constitutional governance, military security, economic systems, and public institutions. Therefore, during situations involving national interest, national defense, or public emergency, corporate participation in national support mechanisms becomes important. The legislature intentionally created a separate provision because contributions towards national defense carry a fundamentally different governance character compared to ordinary donations or political funding. The law recognizes that national defense support should not become unnecessarily obstructed by procedural complexities. Now let us carefully understand the statutory framework. Section 183 states that the board of directors of any company or any person or authority exercising powers of the board may contribute such amount as it thinks fit to the National Defense Fund or to any other fund approved by the central government for the purpose of national defense. Immediately, one extremely important distinction becomes visible. The provision gives broad authority to the board. Unlike Section 181, there is no 5% profitability threshold requiring shareholder approval. This means even substantial contributions towards National Defense Fund can be approved directly by the board itself. This reflects legislative trust in national interest-oriented spending. The law intentionally provides operational flexibility. Now let us understand the phrase, such amount as it thinks fit. This gives discretionary authority to the board. However, this discretion is not arbitrary. Directors still remain bound by fiduciary duties under Section 166. The board must act in good faith, apply proper judgment, and ensure contributions are genuinely connected with approved national defense purposes. This becomes important from governance perspective. Even patriotic provisions require accountability. Now another extremely important phrase appears. National Defense Fund or any other fund approved by the central government. This means Companies cannot randomly classify contributions as national defense related. The recipient fund must either be the National Defense Fund itself or another fund formally approved by the central government for national defense purposes. Professional due diligence therefore becomes essential. Before approving contributions, companies should verify government approval status, nature of recipient fund, purpose alignment, authenticity of approval, documentation validity. This becomes especially important during audit and compliance review. Now let us understand why shareholder approval is not mandated here. The legislature likely recognized that national defense situations may require speed, confidentiality, operational flexibility, and centralized governance response. If every substantial contribution required shareholder meetings, emergency responsiveness could suffer. Therefore, the law places confidence in board level decision making. This reflects an interesting governance philosophy where national interest receives procedural prioritization. Now, let us discuss board meeting compliance requirements. Although shareholder approval is not required, board approval remains mandatory. Therefore, Section 173 and Secretarial Standard 1 become relevant. Notice of board meeting should properly disclose nature of proposed contribution, name of fund, government approval details, amount proposed, purpose and rationale, financial implications, governance considerations. Professional drafting of agenda papers becomes important because future audit review may examine whether directors exercised proper diligence. Now, another important practical point. The board resolution should clearly record that the contribution is being made under Section 183. This creates documentary clarity. Many companies make drafting mistakes by passing vague donation resolutions without referencing statutory authority. Precise drafting improves governance defensibility. Now let us discuss whether interested director provisions become relevant. Generally, national defense contributions may not involve personal interest situations. However, if any director has direct association with recipient entities or approval structures, governance prudence demands proper disclosure and evaluation under Section 184 principles wherever applicable. Now, another important concept. Section 183 allows contributions by any person or authority exercising powers of the board. This phrase becomes relevant in situations involving committees, administrators, resolution professionals, or authorized authorities legally exercising board powers. This creates operational continuity even during unusual governance situations. Now let us understand accounting and disclosure implications. Contributions under Section 183 should be properly reflected in financial records and disclosures. Auditors may review authorization validity, classification accuracy, supporting documentation, government approval verification, accounting treatment, disclosure consistency. Although the provision itself is short, financial reporting implications remain important. Now let us discuss connection with CSR under Section 135. This is an area where many professionals become confused. Can contributions under Section 183 qualify as CSR expenditure? The answer depends upon Schedule 7 and applicable CSR rules. Certain contributions to specified funds connected with national relief or national welfare may qualify under CSR framework subject to statutory conditions. However, automatic assumptions are dangerous. Professionals must separately analyze CSR eligibility. This is extremely important because incorrect CSR classification can create compliance violations. Now let us discuss practical governance situations. Suppose India faces a national security emergency and the central government appeals for corporate support through approved defense funds. A listed company decides contributing significant amounts towards national defense preparedness. The board convenes a meeting urgently. Directors evaluate financial position, public responsibility, stakeholder expectations, and national interest considerations. After deliberation, the board approves contribution under Section 183. This represents a classic practical application of the provision. Now imagine another situation. A company contributes large sums to an entity claiming national defense connection without verifying central government approval. Later investigations reveal the fund lacked official approval status. Immediately, governance complications emerge. Auditors raise objections. Shareholders question due diligence failures. Investigative agencies examine transaction legitimacy. This demonstrates why verification procedures are critical. Now let us discuss applicability across different categories of companies. Private companies can contribute under Section 183. Public companies can contribute. Listed companies can contribute. Government companies can contribute. OPCs theoretically may contribute depending upon circumstances. Small companies and dormant companies may rarely encounter such situations practically, but the legal framework still exists. Listed entities, however, face enhanced governance sensitivity because public disclosures and investor scrutiny become stronger. Now, another important practical insight. Unlike political contributions under Section 182, Section 183 does not carry the same political controversy because the focus remains national defense rather than political influence. This distinction is extremely important. National defense support and political funding are fundamentally different in governance character. Students and professionals must never confuse Sections 181, 182, and 183. Each provision serves a completely different legislative purpose. Now let us discuss role of company secretary. The company secretary acts as compliance and governance coordinator. The CS ensures proper board procedures, correct agenda drafting, verification of approved fund status, minutes drafting, disclosure coordination, documentation preservation, compliance advisory support, audit coordination, governance defensibility. The CS also advises directors regarding legal distinctions between charitable, political, and national defense contributions. Now let us discuss role of chartered accountant and auditor. The CA evaluates accounting treatment, disclosure requirements, internal controls, and financial impact. Auditors examine statutory authorization and supporting evidence. Improper classification or insufficient documentation may trigger audit observations. Now, another hidden governance concept. Even though Section 183 grants broad board discretion, directors must still consider stakeholder impact and financial prudence. Suppose a financially distressed company contributes disproportionately large amounts despite severe creditor pressure. Questions regarding fiduciary responsibility may still arise. This demonstrates an important corporate law principle. National interest flexibility does not eliminate governance responsibility. Now let us discuss connection with Section 166. Directors remain obligated to act in good faith in the best interest of the company, employees, shareholders, and community. National defense contributions often align strongly with broader stakeholder and national interest considerations. However, directors must still ensure decisions are rational, documented, and properly authorized. Now, another interesting practical issue. Can shareholders challenge contributions under Section 183? Technically, if directors act malafide, beyond statutory authority, or without proper verification, shareholder challenges may arise. However, courts generally respect bona fide board decisions made in good faith for legitimate national purposes. This connects with the famous governance principle known as the business judgment rule. Courts usually avoid interfering in genuine commercial or governance decisions unless bad faith, fraud, or abuse becomes visible. Now let us discuss secretarial audit perspective. Secretarial auditors under Section 204 may examine board authorization, compliance with board procedures, accuracy of minutes, disclosure standards, governance documentation, supporting evidence. Although Section 183 does not involve extensive procedural filings, governance documentation still matters significantly. Now let us understand ROC filing implications. Section 183 itself does not prescribe any dedicated ROC form specifically for such contributions. However, board resolutions and financial disclosures become part of statutory records and annual reporting systems. Companies should preserve complete documentation for inspection and audit purposes. Now, another practical governance angle. Large contributions by listed companies towards national defense may create positive reputational impact. Investors and stakeholders may view such actions as socially responsible and nationally supportive. However, governance transparency still remains important. Opaque disclosures or questionable recipient verification can still create reputational risks. Now let us discuss interaction with income tax law. Many contributions towards approved national funds may carry separate tax implications under income tax provisions. However, Companies Act compliance and tax deductibility are separate analyses. Professionals must evaluate both independently. One of the most common practical mistakes is assuming that approval under one law automatically guarantees compliance under another law. Corporate compliance never works that way. Now let us discuss practical drafting precautions. Board resolutions should clearly specify statutory authority under Section 183, name of approved fund, amount approved, mode of payment, verification of approval status, purpose of contribution, authorization for execution and record maintenance. Good drafting prevents future compliance confusion. Now, another important professional insight. Companies should maintain copies of government approval notifications, payment proofs, board papers, minutes, supporting communications, acknowledgement receipts. These documents become extremely valuable during future audit, inspection, or governance review. Now, let us discuss investor perspective. Modern investors increasingly evaluate ESG standards and corporate citizenship. Responsible participation in nationally important initiatives may strengthen brand perception. However, governance transparency remains essential. Investors appreciate patriotism combined with accountability. Now, another important examination trap. Students often incorrectly assume shareholder approval becomes necessary for large contributions under Section 183. That is incorrect. Board authority itself is sufficient. Another common mistake is confusing national defense contributions with CSR or political contributions. Another mistake is ignoring central government approval requirement for recipient funds other than National Defense Fund. These distinctions are extremely important in professional examinations and practical advisory work. Now let us discuss governance philosophy behind Section 183. Corporate law recognizes that companies are not merely economic entities. They are also participants in national development and national stability. During extraordinary national circumstances, corporate participation in supporting defense preparedness and national security may become socially valuable. Section 183 therefore creates a governance framework enabling responsible corporate participation without excessive procedural rigidity. Now let us discuss litigation risk analysis. Although disputes under Section 183 may be less frequent compared to political funding controversies, governance scrutiny can still arise where recipient authenticity is questionable, approvals are improperly verified, funds are misclassified, financial distress makes contributions appear imprudent, disclosure practices lack transparency. Therefore, governance discipline remains essential. Now let us discuss role of advocates and legal advisors. Corporate lawyers advise boards regarding legal validity, recipient eligibility, documentation quality, governance defensibility, potential litigation exposure, disclosure considerations, regulatory interpretation. This becomes particularly important in large listed entities where governance sensitivity is high. Now, another practical illustration. Suppose a company contributes to a newly formed trust claiming national defense support without verifying central government approval. Years later, investigation agencies discover irregularities within the trust. Even though the company originally intended patriotic support, weak due diligence may expose directors and officers to scrutiny. This demonstrates why governance discipline is necessary even in patriotic transactions. Now let us move towards practical conclusion. Section 183 may appear concise in drafting, but it reflects a deeply important governance principle: the relationship between corporate responsibility and national interest. This provision empowers boards to support national defense initiatives efficiently. It reflects legislative trust in corporate governance systems. It recognizes the broader social role of companies within the nation's economic and security framework. For company secretaries, this provision represents procedural governance and statutory clarity. For directors, it represents responsible corporate citizenship combined with fiduciary discipline. For auditors and advocates, it represents governance verification and legal defensibility. For investors, it reflects how companies balance patriotism with accountability. And for governance professionals, Section 183 demonstrates that corporate law is not merely about profits, filings, and transactions. It is also about ethical participation in national responsibility, institutional trust, and responsible corporate conduct during matters affecting the nation itself. If you like this video, kindly like, subscribe, and hit the bell icon for latest notifications from Corporate and Securities Law Compass. Like, share, comment, subscribe. Disclaimer: viewing this video or accessing the content on this channel are free and does not create any professional, advisory, or client relationship between the speaker and the viewer. The content is shared solely for general educational and informational purposes. The speaker is a member of the Institute of Company Secretaries of India, ICSI. However, the information provided in this video should not be construed as professional advice, consultancy, or opinion under any law or regulation. Viewers should not rely solely on the information provided in this video for making legal, financial, regulatory, or compliance decisions. Any person intending to rely upon or act on the information contained herein should independently verify the relevant provisions of law and, where appropriate, seek professional advice from a qualified professional. The speaker, the Institute of Company Secretaries of India, ICSI, and any organization or listed company with which the speaker may be associated shall not be liable for any direct or indirect loss, damage, or consequences arising from reliance on the information provided in this video or channel. The content shared on this channel is based solely on publicly available information, general legal provisions, and academic discussion of corporate and regulatory frameworks. The speaker confirms that no unpublished price-sensitive information, UPSI, confidential information, or proprietary information of any listed company or organization has been disclosed or discussed in any video or content on this channel. The views expressed in the videos are personal academic interpretations for educational purposes only and are not connected with or derived from any confidential information obtained through employment, professional engagement, or association with any listed company or organization. Nothing contained in this channel should be interpreted as market advice, investment advice, or insider information under the applicable provisions of securities laws, including the SEBI Prohibition of Insider Trading Regulations 2015. Viewers are advised that the information shared is purely for general educational awareness and should not be relied upon for investment decisions, trading decisions, or regulatory compliance without consulting appropriate professionals and official sources.